One question we hear a lot in our office is, how long do I have to open the estate after a loved one passes away? This question can take a lot of different forms. How long do I have to file the will for probate? How long do I have to get someone appointed to manage the estate? How long do I have to go to the probate court? But they're all asking the same thing. We're going to answer that question today. My name is Eric Brohl. I'm the founder and CEO of Georgia Probate Law Group. We focus exclusively on helping families with situations after a loved one has passed away. Many times we help families with getting the estate right, and many other times we help with litigation and disputes when families are not as friendly. Let's get into our question for today. So, how long do you have to open probate after a loved one passes away? So the question itself, I'll come clean with you, is deceptive to begin with. There is no time frame under Georgia law that says you must open an estate by this many days or this many months after someone passes away. So from a legal standpoint, I don't have an answer. There is no minimum amount of time that would have to pass or maximum amount of time that could pass, and you have to open the estate within this window. That doesn't exist under Georgia law. But as a practical matter, you're going to want to open the estate relatively soon. Most often what we see is anywhere from about 2 weeks to 2 to 3 to 4 to 5, as long as 6 months. That's kind of an average of what we see in our office. Yes, we absolutely do have folks that will wait a year or 2 or 3 and then open the estate, and that's fine too. But practically speaking, there are some things that you would miss out on by not opening it right away. First of all, real estate. There's no ability to transfer real estate that a deceased person owns without opening an estate. Second, if there are funds in a bank account or an investment account, and those funds are not a beneficiary designated account, then there would be no way to gain access to that either. Third, if there were any other titled assets or any other transactions that needed to occur, those transactions could not occur either. One example I can give you that happens, unfortunately, more than we would like it to, is sometimes a family needs to pursue a wrongful death lawsuit. In order to pursue that lawsuit, the estate would have to be open because the estate would have to be a party to that. And so that can cause an estate to be opened quickly as well. One final note to be aware of. If there's a will, and if you're in possession of an original will, while there is no duty, there's no legal obligation for you to go and open the estate with the probate court, there is a legal obligation for you to turn over the will to the appropriate probate court. And what I mean by that is you take the will into the court and you hand it over to the clerk of court. You're not required to do anything else, but you are required, if you have the original will, to turn it over to the probate court so that it's now on file. And you need to do that relatively quickly. I would say certainly within 2 months. Hopefully that answers the question. Thank you for watching. If you have any other questions or would like to talk about your own situation, please give our office a call. We'd be happy to help. Thank you.